Good evening, everyone.
Good evening.
Welcome to this joint public lecture by the Center for the Study of Existential Risk and the new Center for the Future of Intelligence. My name's Hugh Price. I'm the academic director of both centers. This is, on the CSER side, this is one of CSER's regular Blavatnik public lectures series, and we're very grateful to the Blavatnik Foundation for their support of this series. It's a particular pleasure for me to introduce tonight's speaker, Professor Neal Katyal. Neal is Paul and Patricia Saunders Professor of National Security Law at Georgetown. And among other distinctions, he was acting Solicitor General for the US during the first Obama administration. And he's also a very successful a presenter of cases in the US Supreme Court. He's argued many cases there. I think it's fair to say a remarkable number for someone who, as you can see, is still a very young man. He's also appeared several times on the Colbert Report, and according to Wikipedia, he played himself last year in an episode of the US version of the drama House of Cards. Now, I know that in the last few days, some people have been expressing the hope that we might all be characters in some kind of dystopian TV drama. But at the risk of dashing that sort of hope, I want to assure you that what we have tonight is the real-life Professor Neal Katyal, not some version of him playing a fictional one. Neal is going to be speaking to us tonight on the topic of technology, transparency, and privacy. So welcome, Neal.
Thank you. It's a real honor to be here with you all. I want to thank Professors Hugh Price and Tom Grant, and Tom in particular, for bringing me here. We knew each other in law school back a while ago when neither of us had gray hair. And I also want to thank the Center for the Future of Intelligence. Look, I know it's 5:30. I really appreciate you coming out late. In America, we would never deign to have a lecture this late. And so I also know that from my students that I have a soporific effect on them at times. And so I will leave a lot of time for questions and get some dialogue going. I know this actually was brought home to me a few years ago. When I went into the Justice Department, I was also teaching at the same time. Just the way it happened, I had to keep my class going. And so I was running from Justice Department to school, back and forth, back and forth. And I really learned what my students thought of me that year. So we have exams at Georgetown are graded blind, so you don't have your name on it. That's because if you had your name on it, you'd see like, oh, Sophia Smith, she was so nice, something like that on the exam. So you're not allowed to put your name on the exam. You have these random numbers. And the students at Georgetown are pretty clever, though. They even though it's a random number at the bottom of an exam, they'll say things like, Professor, thank you for the best class ever, or, your ties are beautiful, or the one that gets me, your children are gorgeous, something like that. And, you can discount all that when you're doing the grading. It's not that hard. But that semester I had someone say, Professor Katyal, if I have 1 hour left to live, I should like to live it in your class. And I'm sitting there thinking, do we have A+ at Georgetown? And in the bottom of the exam, it says, there's a footnote. Law students in America, at least, they love their footnotes. Footnote, it says turn the page over. Turn over. That is because, Professor, you make 1 hour seem like an eternity. So, with that in mind. So, Election Day, of course, is on our minds. I want to start by telling you about a different election, the midterm election in November 2010. So, that's, in our system, we, every 2 years we have congressional elections for all of the House of Representatives and for 1/3 of the Senate. So these are big deal elections for us. Facebook decided to conduct an experiment that day. They wanted to see if they could make people vote. And so they took 60 million Americans and they tinkered with their users' news feeds. So one group saw an interactive graphic which included pictures of 6 of their friends who had already voted, and a button to click if you had voted yourself, and a link to look up polling places. That's group 1. Group 2 is Similar graphic, but it's no pictures of friends or anything like that, but just a count of all the Facebook users who had voted. Just, a raw number. And the third group sees no message at all. And once the election is over, Facebook cross-references their subject names with actual voting records to see who actually voted. So users who saw only the vote count were voted basically at the same rate as users who saw no message. So baskets 2 and 3, same thing. But the interesting thing is the first group. So those who saw pictures of their friends were 0.39% more likely to vote for the control groups, an increase of 60,000 votes. And it also created a ripple effect where the Facebook friends of people who had seen that first group were more likely to vote, even if they hadn't seen the graphic themselves. Altogether, Facebook calculated their experiment led to an extra 340,000 votes in the 2010 election. Now, 340,000 votes, you think the country of America, 300 million or so, that doesn't seem like a lot. Then you think about what happened last week. Donald Trump wins by winning Wisconsin, Michigan, Pennsylvania, and thus the election with just 100,000 votes combined, in extra 100,000 votes combined. Now, I think a lot of people will find this manipulation unsettling. I think it's been known to political scientists for a long time that you can influence who's going to vote by social pressure, that if all your friends are voting, you're more likely to vote. But what the experiment shows is that Facebook can actually be a mechanism, technology can be a mechanism to deliver that social pressure. And the risk is obviously not that Facebook is just going to get people to vote, but assume, or suppose that they actually had a political agenda in mind. So Facebook certainly can tell right now, based on the data they have of who your friends are, what your news feeds are, they can predict your party affiliation and who you're going to vote for. And what if they only showed that first group of messages, the ones with your friends voting, to people who were of the political party that they wanted to see in power? Harvard Law professor Jonathan Zittrain calls this digital gerrymandering, and it demonstrates the risk, the subtle risk posed by digital algorithms and other technology that can generate, process, and deliver information with unprecedented efficiency. And, look, just in terms of raw amount of data, it's been increasing massively, as has the ease by which the information circulates across the globe. So Eric Schmidt of Google once estimated that all human knowledge accumulated from the dawn of time to 2003 was 5 exabytes. And a byte is one letter or number, so an exabyte is a billion, a quintillion bytes. So 5 exabytes sounds like a lot. This June, Cisco estimates that by the end of this year, annual internet traffic alone is going to reach a zettabyte, which is 1,000 exabytes, just annually, in 2016 alone. Only half of that's pornography, I think. By enabling the torrent of information, digital technology has radically reshaped politics, the media, the global community, social interaction itself, and it's also undermined longstanding assumptions about privacy and the laws that protect it. So I see privacy in this information age as a twofold problem. The first part is the volume of personal information that's electronically accessible. Everything is now leaving trails of data, from our clicks on our mouse to all sorts of things like that. And also we're storing a lot more electronically, like our health records obviously used to be stored on paper. Now it's stored electronically. And as we get into the Internet of Things and our refrigerators and and our Nest thermostats and our self-driving cars, all of that, more and more data is going to be generated. And then the second part is, of course, what can governments but also corporations do with this data? How can they mine the data in ways that are particularly pernicious? And so these two facts together mean that strangers at a distance can now generate a very high-resolution portrait of someone. And it invites the possibility of abuse, both on the government side in terms of surveillance and what it can do, but also on the corporate side. And so the talk today is really, and it's been written with my, I've had a lot of help with my researcher, David Whipple, on the talk, is to really think through these problems and what the legal architecture is to try and restrain this. And basically in the past, you had public objections to kind of intrusive surveillance, and you had limited resources. Those are the two basic constraints. Cost. It's just expensive to surveil everyone electronically or otherwise. And those are the two constraints. And the new technologies, however, make both of those harder. Subtle stuff like the Facebook example I was telling you about earlier. It's hard to actually generate public opposition. It's hard to figure out what they're doing. It often can be done in secret by corporations or by the government. And of course, cost is also very different because the massive amounts of data and all of our processing power makes it possible to generate and exploit data much, much more cheaply. And this allows, really, I think, some really dangerous consequences to unfold. And let me just tell you one story about an American store, Target. It's a chain store, big, they sell everything, basically, in 2012. So retailers have long known that, obviously they want to sell you stuff. Most people have kind of fixed buying patterns and selling patterns. They buy the same stuff all the time. There's one point in time in which things totally change. And that's when a new baby is born. At that point, a whole bunch of new products are sold and existing spending patterns get disrupted. And baby notices are generally public, and the birth of an individual, and so companies have gotten those for a long period of time. Has gotten that information and send mailers and all sorts of other stuff to someone who has a new baby. All sorts of things, strollers and cribs and that kind of stuff. So Target in 2012 says, well, let's get ahead of that curve. We could do something more than whatever all our other competitors are doing. So they get their statisticians together and they say, look, we've got a lot of data of what people are buying. Can we take all of that data and figure out, is someone pregnant? Can we do that? The answer, yeah, they can. And so what Target does is what Target realizes is based on 25 different factors, they can predict pretty accurately, is a customer pregnant and when will they deliver? But there's a problem. They understand that if someone gets a thing in the mail saying, oh, you're pregnant, or it gets, like maternity clothes ads or strollers or something, it's going to have the creep factor increase massively, of course. So what does Target do? Well, Target says, oh, we know what to do here. We're going to send those people the maternity clothes ads and the strollers ads, but we'll bundle in a lot of other irrelevant stuff too. So the lawnmowers, get bundled in. So it doesn't look like they're being targeted based on the data that the algorithms, kind of uncovered. And then Target tries to keep the secret. Indeed, the New York Times reporter who breaks this story is barred from trying to enter the premises because they know what story that he's writing. And so Target is using its data to ask its customers ask its statisticians to figure out among its customers a specific, certainly intimate detail about its own customers. Now, there's also other companies that have proliferated in America, Axiom being the biggest example, which collects data by other people and then generated by other stores and information sources, and tries to aggregate it in ways, so they have 190 million people in the United States, 500 million people around the globe, I think, profiles, and each data profile has about 1,500 different points, everything from credit card purchases to divorces and so on. And obviously these data profiles could be misused. You could imagine them being used to target vulnerable groups, people with gambling problems, easily fooled old folks, people, if you're an insurance company, you want to take lower risk customers, so you may look at their health records, things like that. So you've got that problem, the corporate exploitation problem. And then on the government side, we all know the risks. Certainly after 9/11, there was first a proposal for the total information awareness system, an idea that would try and mine up all this data and use it to try and uncover terrorist and other national security threats. That program was obviously shut down, but now in the wake of any number of revelations, we know that there's other programs that have been going on in bulk collecting certain metadata. And it's not just the NSA, our National Security Agency, it's law enforcement and institutions as well. In 2012, there was a revelation that hundreds of police departments were routinely tracking people's cell phones without warrants, figuring out where they were on a minute-by-minute basis, generating that record. Law enforcement agencies today, including state and local ones, in America are using drones more and more to try and get surveillance, aerial surveillance, and things like that. And, we haven't seen so far in the recent batch of NSA revelations kind of horrible instances of abuse. Quite honestly, it seems like the most the Snowden revelations have gotten is, 7 people, I think, at the NSA who were spying on, their girlfriends, love intelligence, was not, so far, we haven't seen, something really pernicious. But, we've had that tradition in America in the past. Richard Nixon ordered the NSA to spy on protesters during the Vietnam War. And obviously the government surveillance capabilities were kind of employed or tried to be employed during Watergate. And we have certainly rhetoric from our new president-elect calling for government surveillance of mosques, a registry of Muslims, and things like that. So some of these, technologies are could be, even if we've had a pretty good record over the last 8 years, the record may not look quite the same way the next time around. One other kind of problem that and then I'll go into some of the kind of legal stuff, but one other problem to think about is also the problem of hacking. So even if the material is collected by, responsible people and only mined in a responsible way, unfortunately, we've seen example after example of the information getting hacked by forces, including our favorite company, Target. That same company, all of their or a good chunk of their data was on 110 million customers was hacked. Yahoo, 500 million accounts hacked, and so on. So Americans, Europeans, and others around the globe, I think, are having their information vulnerable, not just because of the initial storage locus, but based on threats posed by hackers and other entities. So my hope today is to use America as an example to how to think about some of these problems, because I don't think actually American law right now works particularly well at protecting privacy. I think it could, and I think there's stuff we can empower it to do, but right now it doesn't. That basically we have a bunch of old laws. They don't anticipate the modern threats posed by companies, certainly, and by government action. And here I think Europe is a little different on that. I think Europe, European privacy law trends to treat companies as really very serious threats in a way that American law hasn't fully embraced. They see the government more as a threat to privacy. And the basic thesis here is that substantive law is not going to work tremendously well in the digital age in protecting privacy, and we need to think about more procedural changes rather than substantive. That legislation is going to be too slow. It's going to be blunderbuss. It can't codify nuances in an ever dynamic, changing technical environment. So in America, our first thing when we talk about privacy is the Fourth Amendment. The Fourth Amendment says, part of our Bill of Rights from 1789 says that you shall have, that basically protects against unreasonable searches and seizures. And built into that word unreasonable, or sometimes the Supreme Court in America calls it a reasonable expectation of privacy, is some flexibility. That is, what is reasonable now might be different than what was reasonable before. I think the best example of this was a case about 10 years ago, a case called United States versus Kylo. So Kylo was a guy, I think he was in California, growing marijuana. And the government, in order to catch him, decided to fly aerial surveillance over his house and thermal imagery, showing that there was a lot of hot, that there was heat coming from there. And the question is that a search? So, in one sense, it's not a search. There's no one's going into the home, which is what the government said. They're simply taking pictures outside of it, emanations of heat outside of it. But Justice Scalia writes, unfortunately late Justice Scalia writes an opinion saying, no, that is a search, that people have a reasonable expectation of privacy. And when a technology, quote, is a device that is not in general public use, a device that's not in general public use is employed by law enforcement, people have a reasonable expectation of privacy against it. And you can see already, wow, that's a real problem, because if the technologies do become in general use, the Fourth Amendment protections go down. And this is the linkage between the corporate sphere and the government sphere. If corporations are doing thermal imagery and it becomes the way, part of what our reasonable expectations are, that then waters down the standard of the Fourth Amendment against the government. So we've got that one set of problems, which is kind of what is a search, How much does technology matter? General public use technology versus new fangled, technology that the public hasn't totally gotten their minds around. And then you have this other really big problem in America, and it's a little technical, but it has huge, massive effects on people day to day. And this is the third-party search doctrine. And so you have this case called Smith versus Maryland in 1979. And the court says in that case that the Fourth Amendment doesn't apply to information that is given voluntarily to third parties. And so what that means is that if the government can make a request from some third party for your information, it could be your bank, it could be, it could be your doctor, it could be, anything. It could be Axiom, it could be Target, that there is no substantive Fourth Amendment protection against that. That, has meant that, for example, when the FBI issues what they call national security letters to banks, which is turn over all this customer information, there is no Fourth Amendment protection against that. So it's a big, big hole in the way we think about privacy in America on the Fourth Amendment side. And then here's another final one that I'll talk about, which is kind of what's in public view. So you have a case called Greenwood versus California, old case, maybe the 1970s. And that's a case which says if you put your trash out on the curb and law enforcement searches through the trash, you don't have any reasonable expectation of privacy because people can go through your trash, anyone could, private citizen, so government shouldn't be seen as any worse than that. So when I was running the Solicitor General's office, we had another case called United States versus Jones, which is kind of the modern incarnation of that. So what's going on in Jones is you've got a guy who's suspected of dealing crack cocaine. And he's suspected of dealing crack cocaine in Maryland. And so the FBI decides to go and seek a warrant to put a GPS tracker on his car. So some little device that'll track all of his movements 24 hours a day. Now, they go and they get a warrant. They get a warrant. The warrant is only for 10 days, and the warrant is only within the confines of D.C. Crackerjack FBI unit decides to, on day 30, put the tracker on and put it on in Maryland. So the warrant doesn't apply. Okay. So then the question is, and it was up to my office and me to defend this, defend this against the claim that this is the government being able to put a tracker on any car, anytime, anywhere. And that that this was not, I had to argue, was not a search. Now, this is not actually that hard, given if you think about that Greenwood case, which again is written in a very different context, trash. But the concept is what's in public view, you don't have a reasonable expectation of privacy for. So, well, what's in public view in Jones? I mean, the tracker just literally tells people where they're driving on city streets. And, certainly FBI agents could follow the guy's Jeep 24 hours a day and keep track of where they went, when, and draw all sorts of connections. So we argued that's in public view. It's just simply aggregating more data and doing it more cheaply. But if you can do it by paying a cop to follow the Jeep 24 hours a day, why shouldn't you be able to, we argued, just have a piece of technology do it? Well, that didn't go over so well at the court, turns out. 9-0 loss. I didn't argue the case. I'd left the government by then. And basically the court fractures into how to think about this. Justice Scalia says, well, it's a search because it was actually physical intrusion. There was a tracker that was placed on a car, and that is trespass under, you all know this better than me, under traditional common law notions. And so that's why it was an unreasonable search, he says. Justices Sotomayor, who's probably our most left-leaning justice, and Justice Sam Alito, who's definitely one of our more conservative justices, they wrote separate opinions. And so they had somewhat separate, philosophies, but basically they agree that's not the right way to think about this. And they don't think it's the right way to think about this because they say there'll be all sorts of technologies in the future that don't rely on a physical intrusion for government surveillance. So I think it was Justice Sotomayor who gave the example, well, suppose law enforcement hacks into your car and puts essentially a GPS tracker on you, on your operating system of your car. Well, there isn't then any physical intrusion. It's just simply done with bits. But shouldn't that be something that has the same kind of privacy implications? I mean, Justice Alito is saying, look, it was really what's doing the work here that someone's physically touched this Jeep by putting the tracker on. That's really where the privacy problem is. I mean, we have in America, when you have parking meters, cops chalk the tires of the car. That means they put a little piece of chalk mark on, and then 2 hours later they come back, and if it's the same chalk mark, they know that you've overstayed your limit. But that's a trespass too. But that's one that we accept. What's going on is not actually the physical problem of the car, as much as Justice Alito said, the fact that it's a technology that's monitoring you 24 hours a day. That's the problem. But that also gets to be, from a Fourth Amendment perspective, really kind of complicated too, because, how is that a search? Just putting a tracker on and collecting information that's in public view has been understood not to be a search under any version of the Fourth Amendment doctrine. So some of our courts started to say, well, and this is what Justices Sotomayor and Alito rely on, what's called the so-called mosaic theory. In the mosaic theory, in the intel world, the mosaic theory is if I can get a lot of different information about you, we can put it together and figure out a composite thing, and the sum is greater than its parts. So here, the mosaic theory says, okay, none of these are searches, when you're tracking Jones's Jeep. None of it's a search on day 1, day 2, day 3, day 4. But if you add it all up together, it's a search. That's a pretty problematic way of thinking about things, because 0 plus 0 plus 0 is always going to be 0. And it's also, kind of leads to all sorts of guessing problems. Well, how many days of surveillance do you need? And what kind of surveillance, and what if it's like 2 kinds, what if it's drones plus the tracking device and so on. Really hard to kind of think about this as judicially being solvable with some kind of just general language like reasonable expectation of privacy from our Fourth Amendment. It's not really going to work. So then there's a move toward thinking about, well, okay, if the Constitution isn't going to work, what about statutes? Why don't we have statutes? Well, we've got some statutes in America. We've got the Privacy Act, which permits the government to collect personally identifiable data, but only for reasons that are specified in a statute or executive order. And the act also prohibits disclosure of that PII information to other agencies. And you've got the ECPA, the Electronic Communications Protection Act of 1986, which requires the government to get a court order to obtain phone and email records in large number of circumstances. And you have the Fair Credit Reporting Act, which requires credit reporters to make their data accurate and to use it only for certain purposes. These statutes are really old. Fair Credit Reporting Act is in 1970, Privacy Act 1974, ECPA 1986. And they aren't really, I think, themselves doing a great deal to limit the amount of information that can be exploited by both the government and by private actors. And so these laws, for example, wouldn't stop Facebook from trying to sway the election. They didn't stop the NSA from the bulk data collection program. And it certainly isn't going to replace the kind of practical checks that have existed to protect our privacy in the past, which are cost and transparency, public backlash, because now it's more subtle and the cost has dropped a lot. So I do want to talk a bit about this kind of the public objection piece of this, because community hostility has been, I think, one of the main things that has reined in the American surveillance system, at least on the government side, from getting too big. But the problem is, as the technology gets more subtle, like the Facebook example, really hard to imagine it working in the same way. And that dynamic, makes it harder for legislation to unfold, because it's really hard to get a coalition of people to care. And it allows the government to do stuff unless they get challenged. So let me tell you a story about that. So we obviously had these horrible shootings last year in San Bernardino in December of 2015, in which 14 people are killed, 21 more are injured. And the couple that perpetrated these shootings were killed in a shootout with the police. And they recover an iPhone from the scene of the crime. And the FBI wants to know what's on the phone. This is an iPhone that has a password protection on it. And so they can't crack it, because under the Apple system, you get 10 tries to crack it. And if you don't do it in 10 tries, then the system wipes itself. So they say to the FBI and the Justice Department say to Apple, we're ordering you to basically break your security protocols and write essentially a new iOS system that allows us to see what's on the phone. Apple decided to fight back. I represented most of the major tech companies in America in the case, including Facebook, Google, Microsoft. And these are companies that routinely comply with requests for data from law enforcement, to the tune of hundreds of thousands of requests a year. When they get it through legitimate, ordinary channels and the request for information is done that way, no problem. But they were worried about what kind of precedent would be set by a government actor forcing them to break their own security protocols. And it was a particularly bad problem because of the source of the authority the FBI was using. The FBI was not using some new statute that says you can go and, law enforcement, you can go and order companies to, decrypt or to break security protocols. They were relying on literally a statute from 1789, okay? So just a couple of years after we got rid of y'all. It was called the All Writs Act, and it just allows that courts to issue writs in exercise of their respective jurisdictions. That's what it says. This is like 80 years before the invention of the light bulb, but nonetheless, this is what the FBI is relying on. They come to the court and they say that we can force the decryption of the information. And we argued, of course, that the FBI shouldn't be able to do that these are broad powers, and without explicit public approval, the kind of key check that keeps our data privacy in place is being eliminated. It's an end run around it. And we said the government should grant itself new powers. If they want to go to Congress and get them and have the public debate, fine, no problem. But you can't do it kind of by saying, oh, Congress, you already decided this, public, you already decided this in 1789. And that was, going a little bit too far. And so that's the kind of democratic deficit that I think, is at play sometimes in these technology things, which is you've got these really old laws and the government lawyers, clever government lawyers, I respect them tremendously, but sometimes using them, twisting them to try and get them to do stuff. That's one set of recent problems. And here's another story about another set of recent problems, which is on the transparency side. So Microsoft this past summer challenged the Justice Department's power to issue gag orders that prohibit them from speaking or notifying anyone when they get a search warrant or a search request for customer data. Okay, so I told you that basically there's all sorts of information that's being held on servers, Google, Microsoft, whatever, and law enforcement often want to get at that information. So, okay, fine, sounds legitimate. They should go after the information, make a request for the information. The information should get turned over if it's an appropriate request, and so on. But what the FBI has been doing for the last decade plus is making those requests and then issuing a court order, getting a court order that forbids the Googles and Microsofts of the world from talking about it with anyone, not just the subject of the information, but anyone else, under pain of potentially contempt of court, and so on. And so Microsoft said, no way. Look, you want to go through normal channels and get the information, fine, but we should at some point be able to talk about it. And it turns out, I think none of the companies had really, talked about it amongst themselves. They all thought separately, it seems a little weird. We have these kind of permanent gag orders. We're never allowed to talk about it. Not just, you can understand why you wouldn't want to tip off the subject of an investigation on day one, but these are, indefinite gag orders. They go on forever. And there are hundreds and hundreds of them happening each month when you aggregate it all. So that's, again, another set of very serious problems, which is the government saying, eliminating that transparency piece of things. So it's hard to know exactly what they're doing. And so it's hard to know what they're doing. The democratic process is not going to unfold the right way, and you're not going to solve the problem. And so, again, you need transparency, and you need some sort of government restraint And obviously those two things are going to work together. That is, the more transparent something is, the more there will be restraints put on the government. But at the same time, as I said at the outset, my thesis is I don't think we can actually do this with substantive restrictions very well. I don't think that we'll see a world in which we're going to have a law passed that says, from the Congress, saying, government or corporation, you can only use data in these ways. There's just too many possibilities, permutations of how to use data and exploit it. You can get the kind of low-hanging fruit, as I think some of the privacy acts and ECPA have done. But when you get to things that are really sophisticated, like the Facebook example I started with, I think it's going to be very, very hard to try and legislate in these areas. And that's particularly true when you talk about the government side of things. So, and I'm going to stop pretty soon, but I just want to outline kind of then where do we go from here. And this is something that I think will have a lot of resonance for any number of reasons that go well beyond data privacy. But what I think is important is that we think about internal separation of powers and checks and balances within the government itself, and particularly within the executive branch itself. So obviously the American system has a separation of powers component which divides power of the government between the judicial branch, the executive branch, and the legislative branch. And that's done, James Madison says in the Federalist Papers, because people in the government are going to make mistakes, and you need to empower other people to be as strong against them. Madison says, quote, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and in the next place oblige it to control itself." And that's their central insight. That's why they set up these three branches of government. My academic work is about how that's not where separation of powers stops. So in the first series of articles, I talked about how you have separation of powers working within the executive branch. So we have different agencies, and they often have rivalrous jurisdiction. So they have overlapping responsibilities. And when you have that kind of competing bureaucracy, you're going to generate friction and often better decisions. So for example, the State Department is going to have a different view than the Defense Department of all sorts of foreign policy consequences. But you don't want to just give turf to one or the other. You want both to overlap, to interact, to debate, to discuss, and ultimately reach a decision based on kind of a clashing of views. There's kind of Washington saying, that where you stand is a function of where you sit. And so the idea is you can take the same person, Colin Powell, for example. He's Secretary of State. He's going to say different things as Secretary of State than he did when he was the head of our Joint Chiefs of Staff in the military. That those are, you're naturally going to do that. And so you could have internal separation of powers that kind of mirrors the structure of the surveillance problem. So you could say, look, one of the reasons why our privacy is at risk is because it's too easy for the government to collect this information and to exploit it. Well, what could you do? Well, you could divide surveillance responsibilities in any number of ways. So you could say, for example, that one agency is responsible for collecting the data, or maybe you can even divide that among several agencies depending on the type of data. And then you'd have another agency that's designing the algorithm and the searches. And then you could insist on kind of basically protocols and relationships so that you can't make a request. The algorithm and the search requesters can't make a very large request, at least initially. That it's got to be kind of narrow, targeted, surgical search. And then obviously if red flags are developed in a particular case, you can go back and have more. But you might want to actually fragment and separate these things, particularly if you're dealing with kind of conventional law enforcement as opposed to kind of emergency, powers, national security stuff. So that's one set of things that I think we want to think about. Another is, my new academic work is about what I called internal squared separation of powers, the idea that within even a single agency, we are building all sorts of checks and balances. The best example of this is after 9/11, the CIA created red teams. And these red teams, kind of elite entities, elite folks that come in, and their job is just to argue against the conventional wisdom of the CIA. and the kind of professional contrarians. And that's the job, and it's worked really well in providing better intelligence, second guessing of assumptions, and new creative ways of thinking about problems. And it's not just the red cells at the CIA. I mean, State Department since 1970 has had what they call the dissent channel. So we have an elite kind of foreign service. You can go take a competitive exam at the end of college, and if you pass it, then you go into our foreign service, be posted all over around the world. And if you're part of our foreign service, you can you have the ability to use this so-called dissent channel, which allows you to send a cable to Washington, D.C., to our very highest part of the State Department, saying, look, I disagree with this proposal, here's how it's actually playing out on the ground, or this policy, or whatever. And anyone can do that, and indeed the person who uses the dissent channel the most effectively in any given year is given an award. So can we think about something like that? Can we think about the fact that, now we have our within each agency, we're empowering competing voices. So the Defense Department has a rule of law office and a humanitarian office. The Commerce Department has an environmental office. Our Environmental Protection Agency has a commerce office. The idea is to cede some dissent. And then you think about the way surveillance generally works in America, and all the incentives on the government level are to just do more and more of it. There isn't really, because you don't want to be the person who said no to that operation. Because if you're going to face the blame. And so the incentives are always or not always, but I think largely skewed in favor of trying to do more and more surveillance. So one thing you could do is start thinking about empowering a dissenting voice within the agency itself, to argue against surveillance. And as repeat players, they develop expertise in the area, and they'd argue against any particular operation. And if they cry wolf every time to the Attorney General or to the FBI director, they're not going to have credibility. They're going to understand that, and so they're going to save their big objections for the ones that matter. But right now, there isn't any sort of professional entity that's standing up and kind of constantly arguing against a particular search. I think, by the way, this could be done in all sorts of other areas like drone strikes as well, to try and to have people almost effectively defense counsel, but not for any number of reasons, but in that role to try and argue against the kind of conventional way that the agency is approaching something. So, that's basically the talk. I think that internal separation of powers can help force the government to act with some transparency and restraint. I think that the subtlety of kind of where search is going is really hard for us. I don't pretend these solutions are easy, but that's why I think conversations like this are so important, because we need to start understanding that the new threats to privacy are not at the level of president ordering break-in of your house and stealing your data, but really, really subtle and fine-grained. And so I welcome being part of this conversation with you, and I thank you for coming, and I'm happy to take any questions that y'all may have.
Thank you very much, Neal. Well, we now have some time for a Q&A. I'll just act as a moderator, and we'll just do it on a simple show of hands system. I'll try to be fair to people in different parts of the room. But you, sir, would you like to talk?
Yes. Dr. Katyal, thank you very much. With respect to the Apple and the FBI investigation, couldn't the FBI have used the FCC and the airwaves that Apple has to use, or licensing that Apple has to use for communications? And then secondly, on the separation of powers, how much power does the executive have in FISA court hearings, the Foreign Intelligence Surveillance Act?
Great. So on the use of the airwaves, what do you have in mind exactly? Because obviously the customer's dead. There's no data being transmitted now over the airwaves. So the phone they want to go back and get past data. So what could they do? Do you have a...
Well, so for instance, on the radio waves, if you tell people to do something criminal, or you advertise or use profanity, the FCC will come in and will take your license. And so in the case of the Apple, where they were using a phone for criminal purposes or potential criminal purposes on the search warrant to the phone, couldn't they use a licensing agreement that they have with Apple?
Yeah, okay. So I think there the problem is there's something called the unconstitutional conditions doctrine, which says basically you can't give people a choice that forces them into kind of an unconstitutional surrender of their rights. And here, Apple does have certain rights. And the idea that, and it'd be one thing if Apple were themselves part of the criminal enterprise in any way, shape, or form. If the terrorists were in cahoots with Apple, and Apple's enabling their stuff. Obviously, then you can, Apple's a direct wrongdoer and all sorts of, investigative powers would be triggered. But here, Apple's purely a passive third party. So the question is, can you threaten them in some way in order to get the information you want? I think the Constitution has something to say about that, and the answer would be no, because that's too extreme a problem, too extreme a remedy for a problem that Apple had nothing really to do with. Your second question is about FISA. So the Foreign Intelligence Surveillance Act was created in 1978 and is a way to try and, when you're dealing with foreign powers, get access to information about them. And it sets up a kind of a secret court in Washington, D.C. The procedures are in secret. The names of the judges, they're drawn from all of our judges across the country, are open, so we know the names. But we don't know how it operates. We don't know what decisions it makes, except that basically it's really, really hard to, if you're a government officer, to lose a case at the Foreign Intelligence Surveillance Act court. That is, they almost always approve. It's like kind of failing a class at Yale. You got to try, if you're the government, to to not get your FISA request approved. So it's well over 99% of requests are approved. And so, and I think, again, one of the problems, and now actually, where new legislation is designed to try and deal with this, it was an ex parte court. So it was just the government coming in and talking to the judges. Nobody argued the other side. And so now, based on this whole internal separation of powers idea, people are now coming in and arguing the other side, or that's about to start. So I do think, hopefully we'll see something that, at least works a little bit better in practice, because the astounding success rate of the government there just, leads me to worry a little bit. As I say, I'm generally a believer in government lawyering and government, I think the government has all sorts of legitimate reasons for doing a huge chunk of what it's doing. But when your success rate is that high, you got to ask, is there a problem?
Jane?
Yeah, I really like your idea of sort of internal opposition. And I just wonder whether you've got any comments on, so to speak, how to keep the culture of them, if such things right. Because there are perennial problems we all know about the regulated capturing the regulator. Or we have something here called the Independent Police Complaints Authority, or whatever it is, IPCC, etc. But it's all ex-policemen, at least, a good number of them are, or they may go back afterwards to top jobs in the police and so on. It's very difficult to keep them honest to their commitments to be the independent challenge.
Yeah.
Seems to me you need a separate career structure, separate loyalty patterns. But on the other hand, you need enough knowledge of those you're regulating not to do it unsympathetically and oppositionally. That is quite a real delicate issue,
right.
How to get it done right.
Right, absolutely. So you do have a cultural issue. And so there's some cultures in which actually the bureaucracy already values that. So many of the most senior people, career people of the Justice Department, for example, operate in exactly this way and are respected and sought out for that reason. And it is a path to be a dissenter in the department. And I don't think that's true, for example, in the Commerce Department in quite the same way. And so then the question is, how do you do it? Well, obviously there's some preconditions. You need to have very strong civil service protections and, make sure that there's no reprisals against people who blow the whistle or who argue against the status quo. And then you probably need to create some sort of elite. We have an honors program at many of our agencies for kind of top people to go in and work for the government, typically on that government side, prosecution side, or intelligence, standard analyst side. You'd probably want to create something that works like on the contrarian side and across the agencies in order for this, I think, to work most effectively. We have some examples of this working. So, for example, in the JAG Corps, our Judge Advocate General Corps, if you become a young military lawyer, you got to switch sides. You got to argue both sides. And you could say, well, maybe that's the path. Like now, everyone's got to do a little bit of the contrarian side. In general, like the way I train my young lawyers is that, I want to make sure that you've argued both sides of stuff so that you can really see it. And, there's certainly going to be risk of capture. There's no question about it. People like to suck up to the president. That's, a serious problem. At the same time, sometimes people get powerful by saying no to the president. Those dynamics definitely are in play in every administration, and I sure hope they will be in this one. You're right that at some level, there's only so much you can do within any sort of system, and that's true with checks and balances as a whole, as our founders thought.
Okay, I've got a sea of hands. I'm going to try and take them in roughly the right order. So you at the back there, the next.
Okay. Thank you very much for a very interesting presentation. I have similar reservations about the internal professional contrarian, particularly in terms of how you protect them from the undue influence of being punished there afterwards. So it'd be interesting to hear what your solutions are on that. But the other question I have is, I thought it was very interesting when you talked about the fact that substantive law isn't going to help the problems of transparency and oversight that are currently there. And you talked about a lot of outdated laws from the 70s, the 18th century, and that makes complete sense. But in terms of a recent law that was passed after the Edward Snowden revelations, there was concern not just about the scope of surveillance by the NSA and other agencies around the world, GCHQ as well here, but also the increasing and very significant exchange of data between the private sector and the public sector. And then in response to the Snowden revelations, you had the USA Freedom Act that was passed in 2015. Are there any parts of that, either substantive or procedural, that you welcome, or some that raise concerns for you?
No, I do. I mean, I guess maybe I might have misspoke by saying, look, I don't think that there's any substantive, role in future there's no role for substantive regulation in the future. That's not my point. My point is that it's really hard to codify them. You're often fighting the last war every time you do. So even the 2015 Act, that's dealing with problems that are before based on supposed revelations from 2010 and so on. We just, that way of thinking, I think, is going to be really hard to work solutions around, given how fast technology and governments and corporations use stuff. And so for that reason, I think legislation will often look pretty watered down by the time it goes through the legislative process, even if in theory we think we could design something more open-ended and flexible. Like in America, we have, for example, the designer drug statute, because, all these kind of pharmacologists are making new different drugs, just taking a molecule and changing them, so ecstasy and all of that. So they now passed this framework statute, which just allows kind of quick government regulation through an agency to make something criminal, and you don't have to go through the whole legislative process. You could imagine, in theory, something similar over privacy. You could say, here's a broad framework, but we're going to delegate to an agency, probably the Federal Trade Commission, the way to enforce it against corporate, misuses of data or so on. But the problem is, I think, the companies will have so much to say about that. And again, not always wrongly. I think that the legislative process, even if in theory we think we could design it in practice, I think we wouldn't. The first part of your question was, you were concerned again about kind of how do you stand up this. I do think that, the fact that it works pretty well in the Foreign Service is, to me, telling that the dissent channel is used. It's used quite a bit, and it's used in ways that reward the people who use it. And so you could do that. You can. We have very serious protections for civil service that have been around since the Pendleton Act, 100 years ago, and we have whistleblower protection. So some of that stuff is going to do something, but at the end of the day, you're going to need some sort of, I think, program, some sort of honors program equivalent in order to get this to work. And I don't think it's going to be easy, but I think that it's a much more likely path toward regulating privacy in a dynamic environment than putting our eggs in the substantive basket alone, which is where we've been for so long in the privacy conversation.
Sorry to labour this point, but I also wanted to talk about your view on the substantive law as well as the internal, what you call procedural safeguards. I was wondering whether if we do start substituting substantive law measures for these internal procedural things, we're lifting our hands from the rule of law as being applicable and act and protecting what is a legal right. So privacy here is a human right in the states against the government is a constitutional right, not against the press. I wondered whether if we simply surrender to the so far ineptitude of brought high level substantive law, we're lifting our hands from saying the rule of law can protect individuals in this area of society, which is fast progress in information technology. So information technology wins over, and I wonder if there's a danger in that. I also wonder whether there's something to be said for the fact that judges who make decisions about what information can be used against individuals have a safeguard as it's their duty to apply the law, whereas individuals who are in channels within government agencies to dissent have incentives, but they will never have that same protection, I think. So I wonder whether that's actually a comparable safeguard for what really is a legal constitutional right.
Right, so it's a great question, and I mean, I think maybe I disagree a bit with even the premise of the question, because to me, to say something is a legal right doesn't, to me, mean that it's a substantive legal right as much as it might be guaranteed to process, what we call due process of law. And so there's certainly individual rights aspects to privacy, and I'm not at all saying get rid of substantive privacy protection. I am saying complement it with these procedural safeguards on top. But to me, that is actually vindicating a set of legal rights that people have. That I actually don't think courts do a very good job at protecting people's privacy, because it requires the court case to be brought. It requires you to even know there's a reason to bring a court case as an individual. It requires, all sorts of, resources to hire lawyers and so on. And then even if you do all of that, you're going to a federal judge, and the federal judge is hearing on the one hand the FBI agent or the former detective saying, we need this information. On the other is like, some mealy-mouthed privacy thing, which, is very hard in practice for judges to value, even though we all in this room very much do. And so to me, actually, it's the front end, it's the government side in which you can do a lot more. And it's the same way as like thinking about like if you're an assistant United States attorney, if you're a prosecutor, so much power. You could throw the book at so many people. And what stops that? It's your own internal restraints. And part of it is culture, absolutely. And part of it is training and how to do the job effectively. But you couldn't legislate it and say, okay, you should only bring cases in X or Y or Z, because the range of possible permutations of what you're going to have to encounter in your job as a prosecutor is too much to substantively outline. And I'm starting to think privacy is moving in that direction. Not always. There'll be all sorts of things that could be regulated. Third-party doctrine, a good example, in which, I think we probably do want to put some substantive restrictions on when law enforcement can just go at and get people's information from third parties. So, so things like that. But as it gets subtler, it's harder, I think, to substantively regulate. But I really appreciate the question.
Gentlemen, yes, please.
I know it wasn't part of the main target of your lecture, but you started with the issue of private surveillance. What is the role of the state or the agencies in acting proactively to prevent private surveillance, regulate surveillance?
Yeah, so, and by private, do you mean corporate or do you mean totally individual? Okay, yeah, so, in America, our Constitution doesn't apply against private actors, so there's no constitutional restrictions. We do have some statutes right now that have started be enforced by our Federal Trade Commission, and a little bit by our Securities and Exchange Commission in this area. But the answer to your question is, it's not like Europe in that sense. I don't think we have nearly the kind of robust privacy regulation as your protectorates in data protection, protectorates and all that have over here. I think that it's inevitable that we will move and harmonize a bit more with Europe in this way. That's just, a function of the international kind of climate in which we're operating. And, so I do think we'll see some changes. But in America, right now, there's a really interesting debate going on between people who think, more regulation is bad, see last week, and then people saying, well, but wait a minute, my privacy, that's something different. I don't want you getting access to that. But again, so far it's been mostly on the scale of, I don't want the government to get access to it. The debate has not been as much about private entities. And, that's why I think we need to have the debate. And, if we can generate from the debate substantive solutions and legislate, I'm all for it. I think it's going to be pretty hard to do in the environment we're in.
Could I ask people asking questions to try to speak up, please, so that our microphone here can pick up the question? Julia, go next.
My question follows on nicely from that one, which is I'm interested in you characterise the All Writs Act, which is very procedural in general, as kind of throwing it off as being quite old, but I mean in its sort of ambitions, it's constitutional. It's similar to a kind of constitutional type. I think it's venerable in the institutional framework. I'm surprised that it's dismissed in that way. And particularly, I think that the specific argument that it gets to is one which is allowing us to kind of miss the ball a bit with what powers the private sector is getting here. Because we're concerned about government surveillance, there's a risk that companies are going to act a bit with impunity against other types of regulation, environmental regulation, privacy here. And did you find it all in that sort of putting the tech company position, that there was any point in their arguments that could have been generalised to more of a resistance of government, the government's role in this? It just felt to me like it was creeping a bit, and it was interesting. I think it's a terrible case in many ways for what it was trying to assert, but it was interesting how civil society was somehow found its side on the same side as the private sector, and then the arguments got all twisted up, and I worry a bit about the legacy of that.
Yeah, no, it's a great set of questions. So, I think there are some laws from 1789 that do have some vintage and and some respect behind them, and indeed even the All Writs Act for what it's really used for, which is if you are trying to get a case to the Supreme Court and there isn't a statute passed that allows you otherwise to assert jurisdiction, you can assert the All Writs Act. That's the kind of thing it was written for, and not to authorize forget about the iPhone. It wasn't written to authorize surveillance in any way, shape, or form. It's directed at courts and the writs that they may issue. So, it'd be maybe one thing if it were something that law enforcement had never thought about before. It was a new problem, and this has never existed before in history. But they had asked for the very power to do this for the Congress, and Congress didn't give it to them. So in that circumstance, at least, I feel like if I'm asking in our system of checks and balances, is there a democratic mandate for the FBI to do this? And the mandate is from 1789, and it doesn't actually talk about the problem. That's a tough argument. Now then you say, well, is that a sign of kind of Silicon Valley or maybe American corporate or corporate in general resistance to regulation? I have to say, and you might accuse me of drinking the Kool-Aid, but I don't think so in this sphere. I think these companies really try so hard to work with the government on this stuff. They don't have any interest in fomenting the bad things. The Facebook example I told you about at the beginning is truly only an example of a nightmare Facebook, not the Facebook that we have. Obviously when you're thinking about designing a system, you have to think about the bad apples that, could come. But at least with respect to this, I felt like this was a really, truly heartfelt and difficult thing because of the, people died in this, and so it wasn't like something I think anyone would come to easily, but the community was pretty united, including companies that I think do a ton of work with the government and really deeply respect it. So I don't think that there's some precedent set by this to say, no regulation anywhere else. I do think there's some unique problems when the government regulates, and this goes back to the earlier question, when the government regulates privacy of, in the corporate sphere, just because they may not totally understand the dynamics of the problem, and the legislation might, create more problems, which might be different than environmental or something in which it's an older problem. Government expertise is more concentrated, and so on. And so that's why I think even if we are to see government regulation over companies, as I said, I think we'll see some harmonization. I think it'll still be broad, open-ended standards, and then would have to be enforced by the Federal Trade Commission in a given set of cases.
Okay, let's have a question on this side. Not you, Martina, I've got you, but the person behind you there.
So I have a question about the procedural safeguards that you mentioned. I think, as you said, they apply when there's an internal separation of powers, but then with the context of intelligence sharing arrangements, etc., where you have, interception of communications and interference with privacy rights and kind of extraterritorial elements, how do you think the regulatory environment should evolve or adapt in light of that, where you don't have national silos of information or laws, and we can't really operate in that context anymore?
Yeah, I guess I haven't really thought much about that yet. I probably should, but I think that basically, what my concern with is entities that are, at least, again, it's parochial, but entities that are operating on American soil, either a foreign company or certainly a foreign government, or the United States government or a U.S. company, and even if the provenance of the data is foreign, being able to put restrictions on its use and exploitation. And so everything I'm saying, I think, would work to solve any of those bundles of information in different ways. But I think it's certainly possible to do and solve, or at least take account of the extraterritorial problem.
Thank you so much for your presentation, and it was very interesting to hear about how at least some parts of government have managed to create this sort of culture of dissent and challenge and internal checks and balances. But how stable do you think this culture is to, heads of agencies being replaced with racist, fascists?
I have no idea what you're talking about. Yeah, so obviously, if the head of the agency is a problem, it's going to trickle down below. Now, but I don't think people appreciate that about the American system. It's only, there's only 4,000 or so political jobs in the entire administration. Okay, there's hundreds and hundreds of thousands of federal bureaucrats. So literally, there's just stuff that they can do to protect people, the bureaucracy, that just never trickles up, and it happens every day. You see it all the time. You see it with the prosecutors that I'm talking about not bringing a case, even if the head of the, maybe even the president says bring that case. All sorts of things like that happen on a daily basis. And so, what I want to do is, in my academic work, is trying to tell those stories and make those, and blow them up as examples for how to behave, and the good that comes from it for the agency, and often, not always, but often for the individual. But we do have what we call a unitary executive model of the presidency in America, which says that the president appoints the cabinet heads, and the cabinet heads, the heads of the agencies, have effective control over their agencies. And at the same time, it's tempered by another view, which is Congress still can set up the agencies and protect them. And so that's why we have anti-retaliation and whistleblower protections and civil service. So, even if, let's say, the new Attorney General is, someone who decides, I really don't like most of these prosecutors, they're too liberal or whatever, or too conservative or whatever, can't dismiss them. It's just against the law. They can dismiss, the Attorney General, I think, can dismiss maybe 20 people out of the 100,000 people at the Justice Department. It's a small number. Now, obviously, a large number of those people, to go to the earlier point, do want to kiss up to the Attorney General. We'll try and do, a good job for the Attorney General. But There's a lot of people, and I just tell you, in the last week, I mean, since I was in the Obama administration, a large number of people are saying, "I am not leaving. I'm staying. This is when it matters." And so, I think we'll be seeing more and more stories like that if some of the bad things that you were positing happen with heads of agencies.
Okay, question at the back.
In your thinking, how do you delineate between data and metadata? Do you see your procedural or substantive rules applying equally to both, or do you see a different procedure for data and metadata? And if you have separate systems, would metadata grow in things that you left? Or do you see it needing to be dealt with by one system that deals with the two together?
Yeah, no, I don't think I draw much distinction. I mean, I do think that metadata, again, is something that is harder for people to get their minds around, and for the kind of constraint of public transparency to work well, because it's just hard to understand exactly how it's being exploited. And so that might require actually more vigilance in that area. But in terms of either substantive or procedural changes, I think they would move together. And certainly you could imagine exploitation of metadata that's pretty minor, and conversely exploitation of regular data, that substantive data that's pretty major, or vice versa. So I don't have a distinction in my mind.
Yes, question at the back.
Hi. Sorry, my question is more of a social question, just in terms of people's attitudes towards their privacy and collection of the data, etc. Do you find that people on a whole just don't really care? Is it that, in the American society I'm talking about, is it that there's a sort of apathy towards collection of the data, and could we possibly be moving to a realm where that's just the norm and that's the expectation that the data is collected, and it's almost a top-down approach in terms of protecting people rather than people saying that's my right?
Yeah, no, it's a good question. I don't pretend to be an expert on this, but I think the one thing that I've read and has been borne out by experience is that people care about privacy when they understand that the particular technique of surveillance could actually apply to them and hurt them in their lives. And otherwise, it's really hard for them to care. And so just to give you two very concrete examples among the place I know best, the U.S. Supreme Court, when the government was arguing that Jones GPS tracker case, it wasn't really clear how it was going to come out one way or the other when the lawyer for the government stood up to argue. Chief Justice asked the government lawyer, who's the Deputy Solicitor General, fabulous Supreme Court lawyer, said, wait a minute, are you saying that because we're in public view, the Jeep is in public view, that there's no reasonable exploitation of privacy? Answer, yes. So then the Chief Justice says to the government lawyer, so you're saying you could put this tracker on my car and that there's no Fourth Amendment protection? Answer, yes. Answer, 9-0 loss to the government. And then just 2 years ago, and I had just cut this out of the talk because I was running out of time, but there was a case called Riley versus California. Again, goes up to the Supreme Court. And the question in the case is, does law enforcement, when they stop you and arrest you, do they have the ability to search your smartphone and see what's on it? There's an old case from 1972, I think it's called Reynolds, which said that if you're being arrested, the government can feel in your pockets, and if there's a crumpled up cigarette case, which was the facts of that, they can open it up and look inside. Why? Because they said there might be contraband inside. There might be, or like a knife or something that could be used to harm the police officer. So you should be able to search for that. And they said you might be trying to destroy evidence. So because of that, they said you should be able to, law enforcement should be able to open up the crumpled cigarette case. Well, state, local, and federal agencies, law enforcement agencies for years had been then taking a cell phone from someone and saying, search incident to arrest. I'm arresting a person. I can open up the phone, just like I can open up the cigarette case and look at everything that's inside. And at oral argument, the government was making this argument, and I think it was, again, the Chief Justice said to the government lawyer, well, wait a minute, you're saying this about a phone, right? Yes. You're saying this about a cell phone, right? And yes. But what about a smartphone? The chief pointed out, smartphones have so much information on them now that, is not just like binary, like what's in the cigarette case. It's your health information, your romantic relationships, it's your movements, it's everything. Doesn't that make it different? Again, 9-0 Supreme Court rejects the idea that there's no privacy protections and the government can't just open up your smartphone and read the information. Again, by making it visceral to them and applicable to them, that's how those cases were won.
Okay, I think we have time for one or maybe two quick questions. Thank you.
So I want to go back a bit to the discussion you were having earlier about sort of private or corporate uses here, because I'm very moved by the argument that says substantive regulation is not going to work very well because things are moving too fast. Which makes me start thinking, okay, well, what sorts of procedural or structural changes were put in place to stop kind of corporate misuse of these? Because earlier in response to a question, you sort of said, well, the government's not going to be very good at that because for various reasons, and that makes me kind of slightly completely confused as to what sort of procedural things you might have in place.
Yeah, no, I'm confused. I'm worried about it. I'm very worried. I don't have actually, right now I'm just trying to draw attention to the corporate side of the problem, but I don't, you don't have separation of powers in the corporate sphere. So, you could imagine it. I mean, certainly, like major companies will do red teams before taking big decisions. So you could imagine, and obviously there's privacy officers at all the big companies, and they do have a large amount of power within, Google and Facebook, for, at least the two examples I'm most familiar with. But absolutely, like how you try and figure that out. And that's why I do think ultimately on there, we're going to probably see some framework statutes that maybe don't substantively regulate, but that give a federal agency the power to go after companies that abuse data, but they'll be open-ended statutes and not too specific is where I think that is likely to go for this reason. It's kind of a different way of dealing with the problem.
Did you have a question? Did you have one? Yes.
Thank you for raising so many important issues and for even suggesting some ideas for how we might go about improving the situation. Going back to the first set of comments you made about Facebook, I'm a little confused in the sense that there's appeared perhaps to be more about influence than about privacy. So we've got people who have voluntarily given up information, and Facebook is using that information as a way to influence them. And perhaps the possible regulations that might be tweaked around that, I'd love to hear your views, seem to me to be closer to things that affect free speech or perhaps marketing of various products, whether that should be free or not. Or do you think that there are other avenues to try to make some progress there?
Well, we might call it something else, but at the end of the day, if the concern about the Facebook example is the company as to which you're giving information to so that you can communicate better with your friends and read the news you want to read, is exploiting that data in ways to manipulate who you're going to vote for and how often you're going to vote, to me, that I call that privacy issue. It does have obviously free speech or anti-democratic consequences, but to me, it is a privacy issue. Now, could you use the lens of consumer regulation, not privacy, to say it's exploitation of data? It may not be private, but it's just misuse of data or something like that. I imagine you could, and maybe there'd be some advantages to thinking about it that way in terms of the politics of the thing. But at the end of the day, I think, the problem is the same, whatever label you put on it, and I don't think it's something that would be that amenable ultimately to government regulation through a substantive statute. It might be something more open-ended, like misuse of information, but something that would be, really try and target this behavior, that just be the next behavior the next day that would evolve into or devolve into.
Okay, I'm afraid we're out of time. Thank you all for coming. I'm going to explicitly allow for the possibility of a dissent channel at this point. But despite that, I'm guessing that you're all going to want to join me in thanking Professor Katyal for